everyone, welcome to video lecture 8 on ASEAN and Security Part 2. Today we will be examining human rights in ASEAN, which again cross-cuts Pillars 1, political security, and Pillar 3, the socio-cultural community. So everyone seems to be talking about, the lack of human rights in ASEAN. You read it in the papers, you read it on blogs. There's a lot of criticism and castigation about the human rights situation in some of the ASEAN countries and about how ASEAN is not managing the regional human rights situation well, right? We will explore the extent to these criticisms and actually see what ASEAN is doing, and also try to understand what our rights as ASEAN peoples are, because I think there is a lot of noise and a lot of discussion about human rights violations in ASEAN, but nobody really actually starts the discussion of what human rights do ASEAN people actually hold. And once we know our rights, how then do we protect our rights in the region and also protect the rights of other ASEAN people, right? So we are looking at this slide on some of the more gross violations of rights in the region, right? There's the drug war in southern Philippines. There is the Rohingya issue, extrajudicial killings, so on and so forth. Right? There are other human rights violations. If you read the human rights reports, we will see that no country in the world, no country in ASEAN is human rights violations free. So to begin the discussion on this ASEAN human rights topic, I want to stress that we are not in the business of, castigating or criticizing certain ASEAN member states or criticizing ASEAN. In this video lecture, I want us to take a scholarly and also practical expert approach. Let's see how we can tackle human rights issues using the terminology and the vernacular of international human rights law and the human rights discourse that professionals use. Some of the issues that we face in ASEAN human rights literature goes back a long way in history. So there will be historical baggage, there will be normative understanding, there will be regional principles, cultural debates. All this we will touch upon in this lecture. So let's begin. On the ideology, we understand that there seems to be an East-West divide on human rights that persists even today, right? The argument of universalism versus cultural particularism, this came to the fore in the 1990s in the Asian values debate. Of course, the Asian values debate is now quelled, but some of the principles arising from the Asian values debate still persist, and we need to see whether, there is merit to the universalism argument, and we also need to see whether there is merit to the cultural particularism argument. And what I mean by this is that nobody should hide human rights violations behind the veneer of, national sovereignty or a certain cultural way of doing things, right? So there should not be a screen to hide human rights violations. But obviously, there are objective truths and merits to, the universalism principles as well as the cultural particularism principles. So we need to examine what these are. Then we go from the international principles ideological idea to the technical substantive doctrine of ASEAN human rights laws in the region. So we need to see where ASEAN human rights laws can be found. The first one is Article 14 of the ASEAN Charter. And obviously, Article 14 is an obligation. The Charter is a treaty. Article 14 says that, ASEAN members are to establish an ASEAN human rights body, right? And then we need to see where other ASEAN human rights norms are found. So besides the treaty of the Charter, human rights can be found in the ASEAN Political Security Community and ASEAN Sociocultural Community blueprints. There is a question whether we can find human rights in the ASEAN Economic Community. So for the blueprints that are standing, that have existed and are now existing, there is no mention of human rights, but there is exploration of whether and how economic rights can be affected or protected and upheld in the ASEAN economic integration progress and process. The AEC blueprint still doesn't mention human rights, but there are policy discussions about economic rights. It's just that it's not gone into the AEC blueprint as yet. And then in 2009, the ASEAN Intergovernmental Commission on Human Rights was established, right, AICHA. And then after setting up this human rights body of ASEAN, 3 years later, AICHA drafted and ASEAN members adopted the ASEAN Human Rights Declaration, the AHRD, in 2012. The debate surrounding the AHRD is whether it meets international standards, because the AHRD is a soft law, right? It is not a human rights treaty, it is a human rights declaration. So there are contentions whether it being a soft law means that international standards of protection are not met. Apart from the treaty versus declaration debate of the AHRD, we also need to examine whether the provisions, the substantive provisions within the AHRD, are robust enough to support, protect, and promote the rights of ASEAN people, right? So what do the provisions say? And then lastly, apart from what the provisions say, are there policies, laws, and ASEAN institutions at the regional and the national level that can be relied on to enforce the enjoyment of the human rights of ASEAN people? Apart from these general laws and general body of AICHA, there are also specific human rights bodies in ASEAN. We have the ASEAN Commission on the Rights of Women and Children, ACWC, and we also have the ASEAN Committee, not a commission, but a committee on the rights of migrant workers, the ACMW, right? There is some argument, and this one is arguably objective, is that the ACWC seems to be a little bit more robust than the AICHA, because the Convention on the Elimination of Discrimination Against Women, CEDAW, and the Convention of the Rights of the Child, CRC, both are UN human rights treaties. These two treaties, CEDAW and CRC, are held in common by ASEAN member states. All 10 ASEAN member states are signatory to CEDAW and CRC. And because in the ACWC terms of reference, this ACWC looks after the rights of women and children and upholds the CEDAW and CRC, it is arguable that ACWC has, hard laws to maintain in the region. Yeah. Now, looking at broader discussions or broader debates in ASEAN, apart from the AICHA, AHRD, ACWC, and ACMW, the common debate is whether the ASEAN human rights system, right, comprising these bodies and these laws, whether the entire ASEAN human rights system is capable of promoting and protecting the human rights of ASEAN people. So we need to examine the mandate of the ASEAN human rights bodies, right, and to see how we can improve the protection of human rights of ASEAN people, right? So protective mechanisms such as petitionary or complaints mechanisms, investigations, concluding reports. The argument now is that there seems to be a lot more promotion of human rights, meaning workshops, conferences, road shows, public education. So teaching people about human rights, right? Promotion of human rights rather than the protection of human rights, which is where, if you have a human rights violated, you are going to come before an institution to ask for accountability and restitution, right? So that's really protection. Another thing that we need to keep in mind when we study ASEAN and human rights is that on one hand, human rights is obviously very important, but on the other hand, states can use the argument of sovereignty and non-interference to block out, investigations of human rights violations. To what extent is that acceptable in the modern day international community? Apart from state actors, which are the biggest state actors in the human rights scene, we need to see who the other actors in the ASEAN human rights environment are. The proponents may be certain ASEAN member states, traditionally Thailand, Indonesia, and Philippines, and obviously from the non-governmental sector, the NGOs such as the Working Group for an ASEAN Human Rights Mechanism, and there's also another ASEAN Working Group that goes by a similar name of a working group, right? And we need to check what the regional mindset of ASEAN human rights is. So, having seen that broad overview, let's examine each of these themes systematically, right? So, we need to find out where our rights are enunciated. If we are ASEAN people, and we have human rights, where are our rights found? Do we find them at the international level, right? International human rights treaties that our countries have signed up to? Or do we find our human rights in the regional level, such as the ASEAN Human Rights Declaration, or as protected by the ASEAN human rights bodies? Or are they found at the national level in the national constitutions, right? Almost all national constitutions have constitutional rights, protection of the rights of the people. So where do we as ASEAN people find our rights best and most strongly enunciated? Do we find them in all three levels, or are our rights stronger in certain levels than others? So maybe if our national protections are very strong, but our countries are not so strong in international law or regional law, then maybe, we would say that our national protections of human rights are stronger than international or regional legal protection. There are some countries which are the other way around, where national protections may not be so strong, and they would have to rely on the international or regional human rights protections because their states have signed up to these treaties or declarations, right? And then we also need to understand whether these are adequate protections, whether, the state has signed up to these instruments and whether these instruments are actually implemented to give adequate protection. Apart from the types of protection, we need to see where the obstacles are to human rights protection in the region. So even if the laws exist, even if human rights bodies exist, what is impeding them, or what could be impeding their proper operation? We need to explore this, right? And if we know the obstacles, how then can we improve the system? And we need to do this not in the kind of NGO type of lobbying way, But as international lawyers, as ASEAN lawyers, we need to examine this conceptually and substantively using the rule of law and the rule of institution tools, right? So the rule of law means the ASEAN human rights laws, and the rule of institutions, which is, the ASEAN human rights institutions. So, ASEAN and human rights. Where do we find the rights? This is a recap of what I went into just now. The laws and institutions are AICHA, right, which is the overarching institution. Then we also have the thematic focus of women and children in ACWC, and we also have another thematic focus, the ACMW, right? So there are three bodies of human rights in ASEAN: AICHA, ACWC, and ACMW. The entire ASEAN human rights system comprising these three bodies take two prongs of human rights work. One is promotion and the other is protection, right? And as I mentioned before, the argument or the debate is whether the ASEAN human rights system is promoting and protecting human rights in the region. Many say that the ASEAN human rights system promotes human rights, but this system does not protect human rights adequately. Okay? And then looking at the obstacles. Where can we find the obstacles to human rights development in ASEAN? As I mentioned before, it can come from history. It can also come from politics, right? The ideas of state sovereignty and norms. ASEAN states' long-running behavior. All these could be promoters of human rights action or obstacles to human rights development in the region. In literature and in practice, the obstacles to human rights in ASEAN boils down very often to the ASEAN Way, right? And the two principles in the ASEAN Way that are hotly debated regarding human rights pertain to non-interference as well as sovereignty. And then the Asian values debate that goes back in history, right? There are the traditional customs of Asian human rights, which are, traditions, customs, mutual respect, national particularities, national, sort of like cultural relativism, so on and so forth. All this comes to the fore in ASEAN. In the literature that we examine for this seminar, we try to understand how human rights developed in ASEAN. True, as mentioned before, the debate is about trying to make sure that human rights are protected in the region, and there is a lot of criticism. But to really make human rights develop further in ASEAN, we need to understand the historical foundations and the historical baggage and obstacles, and only by understanding them can we forge a way forward, right? So while people say, it took such a long time for ASEAN to develop human rights, and then when human rights came about in ASEAN, it is not very good, let's see what the developments were to enable us to even have a breakthrough of human rights in the region, right? So ASEAN actually took 4 decades to enshrine human rights in the Charter, right? From 1967, and then it was really only in 2007 that human rights became enshrined as a treaty obligation in the Charter. And the Charter holding human rights as an obligation is considered a breakthrough, but thereafter there is criticism that there is continuing reticence of, against human rights development. Some of the reasons against the, further development of human rights, especially civil and political rights, can be found in the economic development and nation building historical past and economic development focus of ASEAN member states. There is also, the vestige of the Asian values debate, right, where economic development trumps civil political rights in the region. And we see this in the ASEAN Human Rights Declaration, where community values are very important and community precedes individual rights. There is also the Asian and ASEAN Human Rights Declaration claim of duties, right? So duties may be seen as more important than rights. And there are also, individual country types of cultural particularism. There is also another, reason why human rights seem to develop very slowly in the region is because of the latecomer theory, where Cambodia, Laos, Myanmar, and Vietnam, when they joined up to ASEAN, they were really more concerned on economic development rather than to pushing for the development of human rights. There is also another theory regarding the very varied different political systems and democratic systems and human rights practices of the ASEAN member states. In ASEAN, we range from, monarchies to democracies, and all this would make it very difficult to find consensus on human rights issues. And of course, there is the cultural norms of the ASEAN way. So if there are these historical, obstacles or cultural obstacles, what made and what continues to make ASEAN states more receptive to human rights? Well, there was the rise of democracy in the ASEAN region. There's also the rise of human rights consciousness in ASEAN because of our broken past and the violations, in every country, and the historical baggage, right? The violations and the historical baggage. And there is also the rise of human rights consciousness in the international community in general. So after the Cold War, there was the rise of international, human rights tribunals, right? Or rather, international criminal law tribunals that pursued justice for the gross violations of human rights. So there is a general rise of human rights consciousness in the world order. There is also external pressure from the international community regarding human rights, especially if countries take development aid, right? And there's also the reputational cost with regard to human rights. National identities have changed, right? So as we modernize, we may take on more and more human rights norms as part of our national identity. And as mentioned, there's the gradual democratization in ASEAN, notably in Indonesia, and so on and so forth. And Indonesia is a great proponent of human rights in the ASEAN region. And of course, there is internal and regional pressure from NGOs or CSOs meaning civil society organizations. So there are all sorts of pressures as well as internal motivations to make human rights grow in the ASEAN region. So how did ASEAN human rights grow really, right? So because of the normative reasons that we saw in the earlier slide, this brought about greater legalization and institutionalization in the region. So, 2007, the ASEAN Charter Article 14 is notable, but there are also stepping stones leading up to 2007, then 2009 with the Aicha establishment, and leading up to the 2012 AHRD. So there are certain stepping stones. So how did ASEAN human rights evolve to come to 2007 and onwards? So in 1993, there was the World Conference on Human Rights, and there was the Bangkok Declaration, where then the ASEAN human rights, ASEAN foreign ministers opened the discussion to consider appropriate regional human rights mechanisms. Around the time of the Asian financial crisis, the 1997 ASEAN Vision 2020, because of the devastation of the financial crisis, caring societies, looking into socioeconomic disparities, economic development, human security concerns, right? All this came into the ASEAN vocabulary. Following the ASEAN Vision 2020, we had the 1998 Hanoi Plan of Action that, tried to execute and implement programs to help economic development, improve the plight of women and children, and to give full effect to CEDAW and CRC. Then we fast forward to 2003 and 2004 in Bali Concord and the Vientiane Action Program, where we see human rights being enunciated for the first time in important ASEAN instruments, and human rights straddles the security community as well as the socio-cultural community. And then we have Article 14 in the 2007 Charter. Now, how does this ASEAN human rights system works? As mentioned, 3 ASEAN human rights bodies with their accompanying instruments. So from 2007, we have the ASEAN Charter. Then in 2008, we have the ASEAN Committee on the Rights of Migrant Workers. In 2009, AICHA was established, right? And AICHA was established, and its mandate is not, limited to the ASEAN Charter, but it also follows the political security and socio-cultural community blueprints, right? And then in 2010, the ACWC was established, and in 2012, we have the ASEAN Human Rights Declaration, and in 2013, we have the Declaration on the Elimination of Violence Against Women and Children in ASEAN. In 2015, we have another treaty, the ASEAN Convention Against Trafficking in Persons. It needs to be flagged out that this 2015 convention, it is an anti-trafficking convention. It is not a human rights treaty per se, but because it acts against human trafficking, it is taken in the spirit of human rights. And in 2018, we have the ASEAN Consensus on the Protection and Promotion on the Rights of Migrant Workers. Right? So you can see on this page the development of ASEAN human rights institutions and laws. Is there a difference between using hard and soft law? Right? Is using a soft law a dilution of human rights protection? All these need to be debated. So we can see from the preceding page that ASEAN's human rights focus is, number 1, general and overarching, right? So there is the general focus that looks at civil and political rights and economic, socio and cultural rights that is within the realm of the Charter, AICHA, the blueprints, the ASEAN Human Rights Declaration, and the UDHR and the Vienna Declaration, which are international laws. Then we see the women and children focus of human rights in ASEAN. We have the ACWC, we have the Women and Children's Declaration, and of course at the international level, we have the application of CEDAW and CRC. For migrant workers, we have the ACMW, the committee, and the 2018 consensus. I want to say that, again, human trafficking cross-cuts above all the above areas. We see the action against human trafficking in the general human rights theme, in the women and children's theme, and in the migrant workers theme. Yeah, and human trafficking can be found, or rather, the action against human trafficking can be found in pillars 1 and 3. So now we have seen the history, the ideology, the law, and the institutions of ASEAN and human rights. How do these all promote and protect human rights? Because the law does say ASEAN will promote and protect human rights. But we need to check, is this really true? And if it's true, how does promotion and protection of human rights work in ASEAN? We need to look at the provisions, right? All this will be fleshed out when you read the seminar sheets. But to give you a teaser, a taste, we need to first look at some of these provisions. ASEAN Charter and Human Rights, we see it in the preamble, we see it in the purposes, Article 1.7, we see it in the principles of the Charter, Article 2, and of course we see it in Article 14. Then in the ASEAN Political Security Community Blueprint, 2025 Blueprint, we find it in this section 8.2.5, right? Promote and protect human rights. Then what else must ASEAN member states do? They need to strengthen domestic legislation and institutions, right? So it's not only at the national level, because ASEAN member states need to ratify or accede to core international human rights instruments and ensure their effective implementation. At the regional level, there needs to be an exchange of information so that member states can advance human rights. And then lastly, we need to share information and promote public awareness. So it's not only that they share information among member states, but there needs to be the informational dissemination and the promotion of public awareness of human rights in the region, right? Because I think admittedly, the knowledge of human rights in the ASEAN region is not as high as we would like it to be. ASEAN peoples often do not know their human rights, especially the regional human rights. So this information dissemination and public promotion of human rights is important. And of course, there needs to be the promotion of the mainstreaming of human rights across all three pillars of the community, right? But as we know, human rights is only found in Pillar 1 and Pillar 3. Pillar 2, the AEC, is silent on human rights. Now, what are the other strategic measures? We need to have intersectoral mechanisms, right? These strategic measures are found in B.3 of the Socio-Cultural Community Blueprint, which tells us in greater detail, the actions of human rights taken in the region. And then we need to have sustainable financing to support human rights institutions, right? Social protection, health coverage, early childhood care, all these are socioeconomic rights, yeah? And then there needs to be regional platforms. So again, promotion of human rights through dialogue, and we need to support, implementation of human rights among ASEAN member states. There are other issues being raised in the Socio-Cultural Community Blueprint. We need to see the effective implementation of ASEAN declarations and instruments on human rights. We need to, apart from, implementing the law and having the law, we need to have stronger institutions. So stakeholder participation is very, very important, right? So all these measures are found in the Political Security and Socio-Cultural Community Blueprints. A lot of what we have seen seems to revolve around promotion, right? We need to promote information, we need to promote public awareness. Yes, of course, protection is important, but from the language that we have seen, there is a lot on protection. So how does ASEAN aim to protect human rights in ASEAN? And the record up to today is not great, because this former, UN Commissioner on Human Rights, Dr. Navi Pillay, she mentioned that when the ASEAN Human Rights Declaration was formed, there seemed to be a falling short of international human rights standards. So Navi Pillay said then that ASEAN should work towards strengthening human rights protection in the region. So what can these protections be? In the ASEAN human rights system, we see a lot of roadshows, conferencing, socioeconomic rights, and strengthening of institutions, but we don't have the protective functions that we see in the UN system of human rights or other regional human rights systems. And what are these protective mechanisms? First would be to have treaty obligations, which means that you could litigate your human rights violations. But in ASEAN, all our human rights instruments are soft law. The only human rights obligation can be found in the Charter. The other protective functions are mechanisms such as reporting. ASEAN has reporting, but it's usually thematic reporting, right? And ASEAN does not have a human rights monitoring system, but this is gradually being improved on. In ASEAN, we also do not have investigations, but again, given the recent, gross violations of human rights and pressure from external and also within the region, there is some form of questioning regarding, dire human rights situations. Not all, but some. And also there's the complaints mechanism that we see in the UN system that we now see in nascent form in ASEAN. ASEAN does have a complaints mechanism for human rights, but it is, I would say it is not a fully formed complaints mechanism. It is more of a quasi-complaints mechanism. But I think this complaints mechanism in ASEAN holds a lot of promise. In other regional systems, such as the European, African, or the Inter-American human rights systems, we see the same protective functions as at the UN level, right? Except that the regional systems seem to go further. There are sanctions, in addition to reporting, monitoring, investigation, and complaints, right? So in the regional systems, we do see, for violations of human rights, there will be sanctions, there will be courts to mete out judgments and justice and restitution. And sometimes in other regional systems, there is a system of national human rights institutions or national human rights commissions, and national human rights ombudsmen, which carry out very comprehensive human rights protective functions. So we do a comparison with ASEAN, what ASEAN has and what ASEAN doesn't have. Now, for AICHA, what is the protective mechanism? We know that AICHA promotes and protects human rights, just like the other two human rights bodies in ASEAN, the ACWC and ACMW. But at the same time, it has to struggle with non-interference, regional particularities, and then the intergovernmental structure, sovereignty structure of ASEAN member states, right? The functions of AICHA, you can see in the terms of reference of AICHA, the functions. Do they seem more promotional or protective, right? And who are these AICHA, representatives answerable to? Are they answerable to the foreign ministers, or are they independent, or are they impartial, and so on and so forth? What is the exact mandate of AICHA representatives? And where does the role of the Secretary General and the Secretariat come in for reporting and monitoring, right? Reporting and monitoring was the informational transparency, excuse me, and the periodic review of the human rights situation in ASEAN. So all these things need to be considered when we examine human rights protections in ASEAN. Based on this mandate, can the ASEAN Intergovernmental Commission on Human Rights promote and protect the rights of ASEAN people? And can the ASEAN Human Rights Declaration promote and protect the rights of ASEAN people? So the ASEAN Human Rights Declaration, let's look at it a bit more closely. It is generally akin to the Universal Declaration of Human Rights, right? And then, as Navi Pillay said, are international standards met because of the, soft law status? We need to flag that there is no non-interference clause in the ASEAN Human Rights Declaration. If any state wants to flag up the defense of non-interference, it is usually used as an ASEAN principle, and non-interference is not found in any ASEAN human rights instrument, and it's not found in any ASEAN human rights institution either. Where the clawbacks or obstacles could come into the protection of ASEAN people's human rights could be under some provisions of the ASEAN Human Rights Declaration. For example, in Article 6 of duties, right? So there's a throwback to the Asian human values debate where, the duties to the state, duties to the community could be stronger than the assertion of human rights. There can be the universalism or particularism debate in Article 7, where you see, yes, ASEAN member states do recognize that all human rights are universal, but at the same time, they need to be considered against the regional and national context. There are other limitations, right? So human rights, but subject to limitations of national security, public order, public health, public morality. And also, ASEAN member states are very concerned about sovereignty and non-interference. So they flag out in Article 9 the avoidance of double standards and politicization of human rights issues. We mentioned this earlier, that the ACWC may have stronger protections by virtue of CEDAW. So through the literature and also the primary instruments of the ACWC, we see the terms of reference of the ACWC, the Women and Children's Rights Declaration, and, the international laws of CEDAW and CRC. The thematic group protection of migrant workers is very tenuous. It is a very hotly contested topic in the region, but we still have a committee and we still have some instruments. Now, rounding up this lecture, we have seen that while on one hand, ASEAN human rights laws and institutions do press forward with promotion and protection of human rights, but at the same time, there may be some limitations and clawbacks, right? Which may not then fully protect the human rights of ASEAN people. If the ASEAN human rights system is insufficient to protect the rights of ASEAN people, then where can we as ASEAN people look for the protection of our rights? In international human rights law, there is the principle of, exhaustion of national remedies, right? So if you cannot find it at your national level, so first level, if your rights are violated, you go to the national courts. If your national courts are unable to protect you, maybe you go to other national agencies like national human rights institutions or the National Ombudsman if they are available. You might want to seek out your parliamentarians, or you might want to seek out your NGOs, right? Or you can seek out the ASEAN human rights system And if the ASEAN human rights system is still very limited, then in accordance with the human rights treaty that your country has signed, right? The ASEAN country has signed, you may want to use that recourse and go under the UN system. And protections could come in under the individual UN human rights treaty regimes. In certain situations, there would be the special rapporteurs. And in a more general cycle, there is the Universal Periodic Review under the Human Rights Council. Lastly, to wrap up, to come back to the complaints procedures, which I say is developing in the ASEAN human rights system. This is a very powerful system, and it is quite gladdening that a quasi one has already arisen in ASEAN, right? Complaining about human rights violations, we complain, then we get investigations, and we get some form of accountability. So all these are important, and how could this work for ASEAN? The new quasi-complaints mechanism and the details can be found in the AICHA booklet as well as the work plan. So interestingly, this ASEAN complaints mechanism arose out of, popular demand. So there were violations and AICHA representatives who were lobbied, and slowly over the years, complaints were received, and now this quasi-complaints mechanism is recognized. So to wrap up this lecture, while it may seem that the ASEAN human rights system is not fully able to protect the human rights of ASEAN people, but I think given the consistent pressure and efforts of the human rights system and of the human rights community in ASEAN, as well as the ASEAN people, and of course the ASEAN states, when all of these factors work and push human rights forward, I think it will take time, but we will surely see some positive developments in the ASEAN human rights system, if not now, then in the future. Thank you.